Okay, welcome to a sneak peek of Russ Riddle, the Anomaly at Law. He's going to be presenting right here in Seattle this Saturday, and I wanted to get a sneak peek and learn a little bit more about Russ before he gets here. So welcome, Russ, and how about we have you start with telling me where you came up with Anomaly of Law?
Oh, that's a great question, Mel. It's a brand that found me, actually. As you can tell, I don't look like a lawyer. Most people don't think so anyway. I don't have the vested suit, all the, proper looks about me. I'm just a regular guy. And I go to networking events or associations, just meeting friends at cocktails or meeting new people. They say, after a while, we're laughing, cutting up, just carrying on about life. And they say, well, what do? You always get that question. And when I tell them, I'm an attorney, you wouldn't believe. All the mouths drop open, and it's almost always that. They say, well, no, what do you really do? And I said, I'm an attorney. And they say, no, you're not an attorney. You don't look like one. You don't talk like one. You talk normal. I like
human.
It's true, and I take it as a compliment. I know what they mean. They mean I'm not the stereotype, and I hope not. I don't want to be. But one lady, she said, you're really an anomaly. And a light bulb went on. I went, attorney at law? Anomaly at law. That's me, anomaly at law. And so that's where that came from.
Awesome. I love that. So for those of you who are joining us, we are using a tool called Zoom. And if you scroll over the Zoom screen, along the bottom, you're going to see a bar. And on that bar is a chat window. If you have any questions throughout, feel free to pop open your chat window and send the question in. I will make sure I ask Russ. And at the end of the session, if we have time, I will unmute people and you can actually talk to Russ yourself. So let's get started with copyright, Russ.
Okay.
A lot of speakers don't copyright their materials. I know I'm guilty of this as well. Do you help us with that? What should we copyright?
Well, if you have it in a fixed medium, you already have copyright. That's a myth. A lot of people, and you're in good company, a lot of people think that you have to file with the Copyright Office to create copyright. And that's what they mean by I haven't copyrighted it. The law actually is that if you have it fixed in a tangible medium of expression, the copyright springs into being. It's sort of like a jack in the box. It's just voila, copyright. If you have ink on paper, if you have it saved in a hard drive, if you have it recorded on a disc of some kind, copyright has already occurred in terms of the protection of the law. Now, we still register with the Copyright Office for a lot of reasons. It's prima facie evidence of the copyright. It's great evidence. And if you end up having to sue someone because they're infringing and you want to sue them under the Copyright Act, you have to have it registered in the Copyright Office. If you have it registered, you can sue for statutory damages, which can be important because sometimes it's easy to show that they infringed. It's not so easy to show, okay, what damages do you have? So the copyright law gives you statutory choice. You can either say, I want to prove actual, or I want the statutory kind. And you can get attorney's fees. So there's a lot of reasons to register, but it's not to create copyright. I can help you register, though.
Awesome. So the next question I have is, I've commissioned the work and I've paid the contractor fee in full. So that means I own everything, right?
Maybe. And this is a big issue. It's a really important one because nowadays, most of us in the speakers world, we don't have employees. Some do, some have big staffs. But most of us, we use independent contractors, whether it's a web designer, a social media person, a photographer, a ghostwriter. It could be a lot of things. And the law is, if they happen to be your employee, the presumption in the law is that employer owns the fruits of his or her employees' creative works if they're acting in the scope of their employment. That's not true with independent contractors. The law is that the independent contractor continues to own the copyright unless it's in writing, you have work for hire language in that writing, and even then, if you stop there, you might be in trouble. And that's because There's only 9 categories under the Copyright Act that qualify as works for hire. You and I can call them works for hire, but if the law doesn't recognize them as works for hire, we can call them man in the moon. It doesn't make them a man in the moon. So you also want to have, the third thing is assignment language. And you'll commonly see that in there. This is ever deemed to not be work for hire or qualify for work for hire. I hereby assign it in perpetuity and that sort of thing. So yeah, you own it if writing, work for hire language, and assignment language. And if you haven't done that, I can still help you. Maybe.
How many words or musical notes of third-party materials can I use under fair use?
Oh, if I could count the times that I've had that question, Mel. I used to work for Barney, the purple dinosaur. I was
Really?
in-house counsel. Yeah, I was in-house counsel at Hit Entertainment. We had Barney the dinosaur, Thomas the Tank Engine. We had Bob the Builder, Angelina Ballerina, lots of other programs. And they would ask me that. The creatives out at the set, they say, okay, we want to use this song. We know it's not in the public domain, but we can't get a license. There's not time. How much of it can we use? How many notes? Tell me how many notes, Russ. I say, I don't know. What song? It depends. And they'll say, oh, come on. There's got to be a rule of thumb of how many notes or how many measures. And I said, no, it depends. There's no hard and fast rule. It's okay, 3 notes. Can I use 3 notes? They're just being sassy with me. I said, well, it depends. And then they're not liking anomaly a lot at this point. They say, what do you mean it depends? I said, well, are you going to use the NBC theme? Bum, bum, bum. That's the whole thing. 3 notes. No, that's not a fair use. Now, if you want to use 3 notes of some John Williams movie score, knock yourself out. No one's going to recognize it, but it's probably fair use. Same thing with words or paragraph sentences in third-party written materials. I can't give that to you. It depends on what it is. And there's a lot of factors with fair use, and it's a case-by-case basis. So we'll talk more about that when I come to Seattle.
So that's a good element, because I also bet it's relevant based on new material versus older material.
Yeah. I mean, it may be in the public domain if it's old enough, or if certain things have happened, and I can help you work through that. Or it could be something that's hot right now, and it could be different elements. I mean, it's the same 4 major elements that we analyze it as far as fair use, but the circumstances do matter. That's a great question.
So let's see. If I credit the source, I'm okay, right?
What do you mean you're okay?
I'm not going to be in trouble with the law. I've got the anomaly of law behind me.
Well, if you got the anomaly of law behind you, you've got a big help. But a lot of people think if they know it's not in the public domain, they know they don't have written permission, but they think that, okay, if I say, all right, this is by so-and-so, and I give them credit and all of that I'll be fine. Well, that's not a defense to infringement. You may be fine from the standpoint of they won't come after you. They feel, okay, he credited me, so that'll be all right. But if they still want to come after you for a technical infringement, they could. Now, it's still good to credit them because A, it's the right thing to do. B, so it's ethical. The other thing is there's this thing called good faith and bad faith damages. And as you can imagine, bad faith damages are a lot higher. You could end up paying a lot more money if they say, okay, they infringed this and they were using bad faith. Well, if I credited them, I'm probably not going to be found guilty of bad faith. At least I had good faith, I credited them, and so the damages would be less. So, yes, you should credit them. Doesn't make you bulletproof, but it does help.
It shows you had good intent even though you didn't know the law.
Sure.
Okay, awesome. There's no problem including a client's logos on my website as long as they're used solely to show whom I've actually presented. Is that correct?
This is the big debate in NSA.
Yes, it is.
Yes, it goes back and forth. And there are lots of NSA folks that have their client logos on there. And before I answer the question, let me say this. For all we know, they have expressed written permission to do that. So this is not a comment about anyone who's doing that. They might have gone through the hoops, buttoned it all up, and they're perfectly okay. But if you don't have permission of your clients to use their logo, even if you're on good terms, I don't think you should. And there's a lot of reasons. A, it could be trademark infringement.
Mm-hmm.
If there could be a showing of a likelihood of confusion as to endorsement, that your client endorses you, or you're affiliated or associated with your client, and you won't know those things just by putting it on there. Circumstances happen. So it could be trademark infringement. It could be a contract breach. You may have a clause in your contract for your event speaking or your workshop session. Workout, what yeah.
Yeah, we're going to break into doing.
You have a clause in that event engagement agreement that says any kind of public relations or PR or anything like that has to be approved. And so you could have violated a contract provision. There's lots of reasons. One of the main ones, though, and I've seen this happen, is it can cause friction in the relationship with you and your client. Some people, they like the free advertising. Some pucker and say, do you have our legal department's permission to do that? I didn't give it to you. And they get all upset, and the relationship can get stressed. So there's a lot of reasons why I would say, unless you ask them, don't use the logo. You can use the name. Most of the time, the name of their company is not trademark. Sometimes it can be, but most often it's not. But the logos almost always are. And so if it's truthful that you've done that for that, you've spoken to the client, you've done a breakout for them or something, you could put a client list names. But it gets a little more dicey when you use those logos. So always get permission. One thing you could do is in your event engagement agreement, have it as a boilerplate clause that they allow you to use that on your website solely for the purpose of showing representative clients, But don't just haul off and start cutting and pasting and putting logos on your site. It can be problematic. It really can.
That's a really good idea, Russ. How often do companies enforce that?
It depends on the company. There are some that are just uber strict. Apple is uber strict. PBS is uber strict. I told you we did Barney and Wishbone and some of those other shows that was on PBS. They were so strict about how we used their logo. So it just depends. We would have clients, our marketing team or our sales team would create a deck. It's their PowerPoint or a marketing deck, and they'd use the prospective clients' colors and logos and all this. And some of the companies loved that. Like, oh, look at this. This is so cool. You cared enough. You tailored this. How neat. And some would go, and it was basically over. No sale. They're offended. Mm-hmm. So it's dicey. It's just easier to, with logos, it's not a situation where you want to ask permission later. I think you want to ask permission, or ask forgiveness later is not a good thing. Ask permission in the beginning, because it's just not worth it. Everything's based on relationships. And why lose a sale? Why lose a client? Why alienate a golden relationship over just put the name of the company on there, not the logo, unless you have permission. It's just common sense.
Do you think it's hard to get permission to use it?
Depends on the company. Sometimes it will be no problem at all. If it's a huge company, Walmart, Coca-Cola, something like that, it might not be as easy. Depends on the depth of the relationship, with whom you have the relationship, contact at the company. And sometimes companies simply have a policy against it.
Okay. That's great. I'm going to open this up now. So any of the attendees, you're welcome to type questions into the chat. And while you're typing your questions, I have a question for you, Russ.
All right.
We're speakers. You know that. We all have one sheets. We all have topic sheets. Where should we always include trademark information?
I would always put it at the bottom. If you have a one sheet, put it at the bottom of that sheet. If you're talking your stuff on your website, have it as a constant at the bottom of every screen. Your copyright notice, and you've all seen that, either the word copyright or the circle with the C inside of it. You don't need both. That's redundant. Both of them mean copyright, but it's not a big deal if you use them both. Just know you don't have to have them both. But have that, the year. The year stands for the first year of publication of that particular material. Your name or your company name, whomever's holding the IP, and then all rights reserved is a funny thing. You used to always see that. It's no longer required in this country as part of the copyright notice. But remember, if you're talking about on the web, it's World Wide Web. And the issue of whether that all rights reserved needs to be, there's grayer in some countries. So if you're talking about your website, I would go ahead and include it. But just have it at the bottom. It doesn't have to ugly up the aesthetics, the beauty of your website. We had that discussion all the time at Barney. Don't ugly up my stuff with all your legal stuff. It just has to be legible, and have it at the bottom. It's no harm to the looks of it, and it can be a small font, but just legible.
Alrighty, so let's see. What is something else? What is something that the attendees for Saturday can either bring with them or be prepared to talk about, since you're going to be doing not only a regular meeting session for us, but you're going to be doing a bonus session as well?
All right, we're going to have all kinds of fun. I say bring anything you want. If you want to bring your manuscript of your upcoming book, if you want to bring a one sheet, other marketing materials, brochures, we may pull up your website and show it and take a look at it together. I've already secret shopped some of your websites, so I have some tips already. And so I'm there to help. I'm there to serve. That's why I'm coming. We'll talk about copyright and trademark. We'll talk about licensing, the different kinds of licenses you need to be aware of. We'll talk about engagement agreements, the nature of how they need to be put together. You may already have some. I'm happy to bring those. I'll look at those. I'll have some forms that I'll share with you guys that you can freely adapt. Just because I'm sharing all this doesn't mean I'm your lawyer, by the way. This is not legal advice. You can hire me if you want, but you just have to have a disclaimer. But we're going to have a good time. I'm there to help you go forward in your business and protect your cash cow. Your cash cow is your IP. We're merchants of information. That's what we're about. Those are our crown jewels, and you need to take care of them. You also need to respect other people's. And so we're going to talk both offense and defense. We're going to just talk about whatever you'd like to along the legal aspects of our business.
So I got two final questions for you. You mentioned your cash cow, and the name of your session is Corral Your Cash Cow. Where'd that come from?
Well, it came from the standpoint of your cash cow is where your money lies, where your opportunity to make money. And so it's your IP, it's your books, it's your sessions, it's your coaching, your consulting, it's what we do as speakers, our products, our services. That's your cash cow. In fact, you'll see, you probably have seen, I'm from Texas, so I'm all about cows, but you've seen the beef cuts diagram of the outline of a cow, and then you've got the T-bone, the sirloin, and all that stuff. I have that kind of design, but it's copyright, trademark. It really, literally is your cash cow. So if you're going to take care of your cow, you need to corral your cow and treat it right. And so we're going to talk about that. And we're going to talk about not rustling other people's cash cows. And I'll tell you what, 99% of the time, I'm not accusing anyone of doing that purposely, but 99% of the time, when that happens, it's inadvertent. They think it's public domain when it's not. They're doing things that they don't realize is a problem. There's not usually any kind of bad faith or ill will. It's just they're not lawyers, so we all have our specialties. And so I just want to share a few tips with you, debunk some myths, and help you go down the right path.
So one final question for you.
Okay.
Contracts. Are we going to talk about contracts at all?
Yeah, we can talk about contracts. We'll certainly talk about the event contract. There's also releases that we have to have in our business. Sometimes you need a photo release from people that you're going to feature. Sometimes you have to post things in public venues because there's far too many people to get a release from every person. You've probably seen those at concerts sometimes. We'll talk about non-disclosure agreements, how you can protect the confidentiality of your materials when you're just kicking the tires with a prospect. All kinds of agreements with vendors, independent contractor agreements. We've touched on that, some of the things that need to be in there, but I'm here to be your legal guy for the day.
Alrighty, I am super excited for Saturday. I get to see you Friday night.
Yeah, I'm jazzed.
So I am looking forward to this. Do you have any final words you would like to leave NSA Northwest with?
Just that I am so excited. I'm honored and blessed to be invited by your president, Mel. I have friends up there, Brian Walter, Bill Stainton, Nick Milanovich, lots of folks. And so I know that some of them might be at the Media Lab or speaking, and there's conflicts. I understand that. I'm coming to meet new friends. I'm excited to be coming to your part of the country.
Awesome. We are super excited to have you, and I think you already know this, but you came as a recommendation from Brian Walter. So
he's a great guy. He and I went to the gun range together. I may even share some of that with you.
Oh, that would be absolutely wonderful because he will be at the tech lab, so he can't.
We'll talk about it. His ears will be burning.
There you go. All righty. Thank you very much, Russ.
My pleasure, Mel. See you soon.
All righty.